Good afternoon. I am Rochelle Klempner, and I am the Chief Counsel of the New York State Courts Access to Justice Program, one of your hosts organizations for today's CLE conference. Next on our a la carte menu is ghostwriting and advice and document preparation. We're very fortunate to have a distinguished panel of lawyers that are going to talk about volunteer legal services programs that provide unbundled assistance to litigants that have court cases. So we're going to hear on my far left. I'm going to give very quick introductions because, as Judge Fisher mentioned repeatedly, their full bios are in your materials. Somebody also asked, the CLE materials are posted online. The materials you have today are just the bios and the agenda. On the far end of the panel, we have Tracy McNeil, who is a court attorney in the New York State court system. She works for the Access to Justice Program. She's a special counsel of Judge Fisher. And she's going to be talking about the volunteer lawyer programs in the run out of the help centers in the Civil and Housing Court, and I believe a Supreme Court program as well. Next to her, we have Kwaku Agyeman. And Kwaku is also a court attorney in the court system. He's in the Supreme Court, and he's going to be talking today about the work that he does overseeing the Uncontested Divorce program that runs in, his program runs in Kings County Supreme Court. Next to Kwaku, we have Britton. Angela is also a court attorney in the New York State court system, and she is going to be talking to you today about the family court advice volunteer attorney program that Mike Williams mentioned a little bit about on the last panel. Next to Angela, you see Mark Weliky. Mark is the executive director of the Queens Volunteer Lawyers Program, and next to Mark is Dora Galacatos, who is the executive director of the Furyk Center for Social Justice at Fordham Law School. The two executive directors are going to present together. You're going to be talking about the consumer debt programs? Yes? Yes. So because we have a lot to talk about on this panel, and then we have a lot of discussion, I'm going to ask all of you to hold your questions until we finish our presentations and we have our discussion, because your questions might be answered before you get to them. So I think we're going to have a co-presentation right now from both Dora and Mark.
Thanks, Rochelle. I'd like to thank Judge Fisher for inviting me to speak today, and also somebody who's very important to us in legal services. That's Chief Judge Lippman. Judge Fisher and Judge Lippman have been fantastic advocates for the low-income community. It's also great to see a lot of my colleagues, partners from other programs here who work with us in the CLARO program and in other pro bono. We have a City Bar Justice Center here, LISNY, NILAG, St. John's Law School is here, and I'd like to thank them for all the support and the help that they give us. And the New York State Bar Association, who's also a great partner with us. A little bit about CLARO NYC. CLARO is a limited scope consumer debt clinic that we now run in all 5 boroughs, and there's one in Westchester, and I think we have one up in there's one up in Erie County. CLARO began about 10 years ago in Kings County, and I have to thank Sidney Cherubin, who's here. We'll hear from him later, from the Brooklyn Volunteer Lawyers, and his partner, Brooklyn Law School, who started this back then and helped us get it up and running about 8 years ago in Queens and Manhattan, followed then by Bronx and Staten Island. And of course, I'm going to thank my partner here, Dora Galacatos, from the Furyk Center at Fordham Law School, who's been a great coordinator for Manhattan, Bronx, and Staten Island. I want to give one other acknowledgement, and that is to Judge April Neubauer, who a little over 10 years ago wasn't a judge. She was the attorney in charge of the Civil Division in Queens for Legal Aid Society for many years. And she was the chair of the Civil Court Committee at the City Bar at the time, and realizing the problem with the volume of consumer debt cases, came up with the concept of the CLARO Clinic for New York City. Judge Moulton did a very good job, I think, of outlining why limited scope assistance for consumer debt was a good idea and was effective. Back in those years, 2005, 2000, up through 8, 9, we had hundreds of thousands of consumer debt cases being filed in New York City, overwhelming the courts, overwhelming legal service providers. And what we knew about it, as Judge Moulton said, was that the business model for these companies, mostly debt buyers who were bringing these suits, was not to litigate the cases, but I think hopefully in their case was to get default judgments and to enforce the judgments. Therefore, they often do not have the documentation to prove their case if it's litigated in court. Therefore, we felt, Judge Neubauer felt, that with the assistance of an attorney who has had training in consumer debt in a clinic setting, that these defendants, these cases, as Judge Moulton said, mostly credit card cases, some student loan, medical debt, would have a very good chance of a favorable outcome when they go into court, even if they're going now alone, because they've been given the tools, the information, which would help them reach that favorable outcome. And again, that might be a dismissal of the case, but also might just be a much more favorable settlement than they would have had without that assistance at the clinic. And now I think, Dora, I'll turn it over to you.
Thank you, Mark. Hello, everyone. Just want to echo Mark's thanks to Justice Fisher and all the organizers for organizing the conference and also for inviting me to speak today. I'm going to talk a little bit about the structure of CLARO, and I would say the theme is it takes a village. CLARO is both a collaborative effort and also a standalone effort. So each one of the CLARO programs is separately operated and administered. There are, the very first thing I want to stress is that we operate under the auspices of the New York State Access to Justice program, and that's been absolutely essential to the success of the program. Justice Fisher, her staff, Lori Mulder, others have been played a key role in convening the necessary stakeholders in helping to facilitate the planning, implementation, and then ongoing operation of the program. The CLARO sessions run in the courthouse, so they take place on a regular basis, weekly in most cases, thanks to Judge Stranieri, at least twice monthly in Staten Island. And the staff serve in a liaison function with program coordinators, and that's been really important in terms of how we interface with the clerk's office and other key court personnel. So each CLARO program operates separately. Usually there are 2 or 3 co-sponsors, and the collaborations are among legal services providers, bar associations, academic institutions, and legal services organizations. I think I mentioned them previously. They each play a different role. In each of the CLARO programs, we have at least one entity taking the lead. Almost always the bar association, sometimes the academic institution. The bar associations provide legal malpractice insurance for the volunteer attorneys, help recruit and train the volunteer attorneys, and often help supervise the attorneys. In terms of the academic institution, the law school, sometimes the college, is a source of law school volunteers, sometimes alumni for volunteer attorneys, and can help with taking on administrative tasks. The role of most volunteer law students is one of helping to screen CLARO visitors. However, in many CLARO programs, there are student practice orders, and under the supervision of clinical faculty or staff, they're also providing limited scope assistance. And finally, legal services programs have been absolutely instrumental in the design, implementation, and ongoing support of the program. At the CLARO programs, which I run, since I'm not in court practicing, we always have a consumer law expert on site to provide backup expertise. They're critical for quality control. They're reviewing all the documents that are prepared by CLARO volunteers. So with that, I just want to turn it over to Mark to talk a little bit about quality control and what we do to make sure that the limited scope assistance is the very best that we can make it.
Okay. As far as the lawyers who, the pro bono volunteers who staff the CLARO clinics, we don't require that they have any previous expertise in consumer debt law. We feel that with the training that we can give them, they can be well prepared to give the assistance at the clinics. The CLARO partners, the bar associations, the law schools, we get together and we have usually a minimum of 2 citywide basic CLARO trainings every year. Those will be about a three-hour class. There's a very extensive manual we've been working on since 2008 and updating regularly. But because the expertise and experience of those volunteers is somewhat variable, it is very important that we have a consumer law expert on site for every clinic session. And I could say that in Queens, it's very important for the consumer law expert actually to do somewhat of a triage. We have lawyers of varying, capabilities and knowledge. So we try. There are some cases that are more complex than others, and we try to get those to the more experienced lawyers. Also in the training, I forgot to mention, our partner, St. John's Law School, regularly gives classes for their students before they come to assist at the clinic. So as I said, I think the triage of the consumer law expert is important. And I think, Dora, you can discuss something else that the consumer law expert can help with.
Sure. One of the things that we faced over time at CLARO was a change in the practice and in the kinds of cases that we saw. Early on, the vast majority of cases that were brought by debt buyers, and with very simple assistance, we could usually do a lot for the CLARO visitor. So most of the assistance was focused on explaining debt collection, explaining the court process, preparing an answer, preparing an amended answer, preparing an order to show cause to vacate the default judgment, and preparing very simple document demands. Over time, debt collection law firms changed their practice, engaged in much more motion practice, engaged in more discovery, and we had to change how we administered the program and basically build capacity. So we have worked on developing model papers which help ensure quality. They help us run the program more effectively and more efficiently. We have also worked with partners such as Pro Bono Net, MFY, and others to obtain foundation funding to help in the development of interactive forms. And all of these are efforts to build our capacity and help volunteer attorneys deliver the limited scope assistance more efficiently, more effectively. I want to just add that over the years, the types of cases that we're seeing has also changed, and that presents challenges. When 90% of the cases are debt buyer cases, which Mark described before, that's a different situation than years later when we saw more original creditor cases, and then more complicated cases like student loan cases, nursing home cases, et cetera. So just to say that the practice hasn't stayed the same, and we've had to adjust and adapt as circumstances evolve.
And just continuing on the topic of training, besides the basic trainings we give, we recognize that, as Dora said, sometimes the plaintiff's bar and consumer debt is changing their tactics, and we might have to change some of our methods. Dora and the Feerick Center at Fordham Law School has been great at helping us with some advanced training seminars for our CLARO volunteers. So these are people who have been helping, lawyers who have been helping at the clinics and are interested in coming out on another evening probably just to have a seminar, an advanced topic. It might be on something stressing about student loan cases or a motion practice. And I think that's been very valuable for the quality of the assistance that's being given at the CLARO clinics.
I want to turn to another critical aspect of ensuring high quality and limited scope programs, and that has to do with the retainer agreement that we ask every single CLARO visitor to read and sign every single time they come. This retainer agreement was originally developed by Brooklyn CLARO, by the progenitors of the model, and then has been adapted by the various program coordinators. It's, I believe there's a copy of it in your COE materials, but what we aimed for was that it was understandable, simple, and yet comprehensive. And as you all know, that's a tough order, especially when people have varying levels of educational background, might not be English speakers. The retainer agreement is also translated into Spanish. So one thing that we do is we train our volunteer attorneys and we train our volunteer students at every juncture. Every single interaction that a CLARO visitor has is going to start with explaining the limited scope nature of the engagement. The student does it at the screening, the volunteer attorney does it at the consultation, and we do it every single time just to make very, very clear what the nature of the limited scope assistance is and the fact that we're not going to be providing full scope representation. We've also worked with Patterson Belknap, which did this in a pro bono capacity, to develop a confidentiality form that we ask volunteers to sign, which makes it explicit that they understand that, you know, under the professional rules, they have an obligation to keep confidential whatever transpires, you know, within the parameters of the limited scope consultation. So those are two important forms. I want to just mention very briefly one other tool that we use, and that's data collection and tracking. Over the years, all the CLARO programs have adapted an intake form, and we collect very critical and basic information about the litigant. We input that information into a database, and we use it to identify trends, to see where our needs are. That's how we figured out that original creditor cases were on the up, and we could document it. That's how we figured out when, for example, debt collection law firms started bringing more breach of lease cases. So that's just another. So I hear that our time is almost up, but I think Mark has one more little note.
A little more?
Okay, well,
Okay.
I think we have a minute.
I just wanted to say that I think one of the reasons why CLARO has, I would say, has been a success. We are giving consultations to thousands of people every year in New York City. We have a lot of great programs that are working with us to make it work, like the Office of Court Administration. New rules on debt collection and on default judgments have come out. The Department of Consumer Affairs in New York City has been very helpful on process server rules. The judges, I can speak in Queens County, the judges are very helpful. Announcements are made about the availability of going to a CLARO clinic. Our partnership with the Volunteer Lawyer for the Day program, which has been very successful. We're referring 400 or 500 people a year to that program, and our statistics have shown that almost probably 90% at least of those litigants, those defendants in these cases, have their case discontinued, dismissed, or settled for a far lesser amount than they were sued for. I'd like to also just, my last thing is to mention that Pro Bono Net, lawhelp.org, these have been very helpful resources to us. We'd like to thank those organizations for their help. And again, I would like to thank the courts and the judges who, I could speak for Queens County, they're very, very receptive to the fact that there's a CLARO clinic. They're referring people to our CLARO clinic every Friday and working, I think, cooperatively with the volunteer lawyer for the day representatives who are helping, and I'd like to thank them for that help.
So I've just been tasked with adding one kind of more mundane aspect of the program and then something a little bit loftier. On the mundane front, but this is important, on the issue of ghostwriting, just want to say, even though it is not required, the CLARO programs with which I'm involved as a policy matter have decided that in every single document that's prepared by a volunteer attorney and reviewed by a consumer law expert, we let the court know that it's been prepared with the assistance of Staten Island CLARO and then the name of the attorney. It is not required under the most kind of recent thinking and ethics decisions, but we feel that it's the best practice to let the court know, and you know what? It's obvious to judges. The judges know. We only have 3 different kinds of model papers, you know? I mean, it's clear. And even if it was somebody else's, it would be clear, you know, that an attorney has done it. And so in our view, if there's a particular problem in a particular case, we can trace it back to the volunteer, to the consumer law expert, and figure it out. Just in closing, it really does take a village, and I think I just echo everything that Mark said. Being involved in CLARO is definitely a highlight in my professional life, and that's because there is so much terrific collaboration, cross-referrals, and the work that we do is enriched by the work of the Volunteer Lawyer for the Day program. It's enriched by our legal services providers who are involved, and it's certainly enriched by our collaboration with the court and everybody else who supports us. Thanks.
Thank you.
Thank you.
So I'm Angela Britton, and I work with the Family Court Volunteer Attorney Program.
Can you hear her in the back?
We good? You can hear me? Great, thank you. So you don't work in family court for the money or the glamour, because there is none, okay? You go there because you want to help people. It's a tough place to work, and I usually do these presentations with Mike Williams, but he was on the panel ahead of me, so I'm a little out of sorts, so if I repeat anything he says, I apologize. But last year, we saw over 250,000 filings in family court, and over 80% of those were pro se, and these are people fighting for their children and for their money. It's the 2 most important things in your life. It's your salary and it's your children. And so many of them are coming in completely unprepared. They can't afford an attorney, and they're not going to get an attorney. So the volunteer attorney program launched in '06, and I've been in family court now for 15 years. I was there when we launched. I can honestly say I'm very jaded. It's a tough place to work, but the program makes a difference. And I see it every single day with the people that come through, not just for the litigants, but for the court staff, the court personnel, the court officers. I mean, we make a huge difference. We have seen, since 2006, over 15,000 clients. And I always feel like I'm going to totally jinx myself when I say this, but we've not had one complaint. It's been 9 years, 15,000 people, and not one complaint. That's completely unheard of anywhere. And in family court, that's insane. So, you know, thank you. So I'm very proud of the program. We celebrate our 10th anniversary next year. We started off just 2 days a week in Brooklyn Family Court with just 6 firms and about 40 attorneys. And we have expanded so much. We are now up to 40 firms and about 300 attorneys. We are in all 5 boroughs, and we even Skype. We're no longer New York City, we're New York State. We Skype upstate to Ontario County once a week. So how do we work? We give 30-minute free consultations. So the attorneys come in and they give these free consultations in paternity support, custody visitation, orders of protection, and guardianship. It is explained to every single client that comes through the offices that it is this limited scope representation. The attorneys are not there to represent you in court, but they're going to give you this 30-minute consultation. And the 30 minutes really, sometimes they're longer, sometimes they're shorter. It's always going to depend on the case that we have. The only requirement we have is that the clients do not have an attorney. I mean, I tell them, look, this is not a doctor's office. You're not coming in for a second opinion. You have an attorney. Talk to your attorney. Our lists fill up every single day, and every single day we have to turn people away. So if you have an attorney, no, we don't take you. We do all the trainings on each. So the majority of the people we have staffing, the attorney staffing, are from the larger firms. I would say about 250 are from the firms, and then we do have the solo attorneys that do staff. We provide all the training for the attorneys. We do live trainings throughout the year. We go out to the firms. We have DVDs. We have orientations that we hold. We want to make sure that the attorneys that are staffing know what they're doing and that are comfortable and happy coming. On site at each one of our sites, we have an experienced family court attorney that's going to screen out every single client. We're going to make sure that they are there for the issues we're talking about, because a lot of times we have people coming in, they just don't know where else to go, and they see a sign free attorney, and they're really coming in with a housing court issue or an immigration issue. So we make sure we're getting them to the right place. I always tell every person that comes and sits down in my office that I'm here to get you help, and if it's not here, we're going to find you where you need to be. So we make sure we screen out all the litigants, and we make sure we're on site there to help the attorneys that are staffing the office. But one of the most important things is we make sure they understand that there's this waiver that they're going to have to sign. The waiver is included in your materials. We made sure we sent it out. And it was a collaboration of the first 6 firms, the coordinators from the first 6 firms, including, yes, the great Bill Silverman. But they all sat down and they worked this out, and it's been modified over the years, and every firm has been, very happy with it and feels like it covers everything they need to know. And it's basically saying, this is my attorney. They are not representing me in court. It's a free service, and it ends when I walk out of this office. Now, they are really working with the clients, and family court's overwhelming. So sometimes they come in with this giant, history of everything that they need, and they're going to sit down with the attorney and go through what's relevant and what's not. The attorney's going to probably be maybe just be the first person that's heard their entire story. And, it's a busy courthouse. You want to tell the clerk everything, and the clerk doesn't have time. You want to tell the magistrate or the referee. And one of our task force went around and determined that on an average, every case before a judge has 7 minutes. So it's 7 minutes to say why your child shouldn't be going on visits with the alcoholic ex. Or 7 minutes to get across that you are about to be evicted and the other person has a third job that they're not reporting, and therefore you should be getting more child support. So it's a lot, and people are overwhelmed. So one of the main things we say is you got to go through what's relevant and what's not. You got to sort through their evidence, because nothing is worse to especially a support magistrate. Nothing is worse, I think, than a litigant walking in with a plastic bag filled with receipts and with bills, and they start sorting it out. I've seen these poor magistrates look like their heads are going to explode when that happens. And what they typically do now is they look at their chart to see, what days the volunteer attorneys are there, and they'll say, oh, good, it's Tuesday. I want you to walk around the corner, and I want you to see the attorneys, and we're going to recall the case this afternoon. And I get a call from the clerk saying, yeah, we sent somebody over. See how fast you can get through with them so we can recall the case hopefully this morning, not this afternoon. So they sort through everything. They hear the whole story. And even when we have litigants that are coming in and we're telling them they're not getting what they want, they're thrilled that someone's actually sitting down and explaining why they're not getting what they want and maybe how in the future they could get it. And they're taking the time, and they're not, how many times I do get, well, on Maury, they do this. And I'm always like, oh my God, we're not Maury, this isn't, you can't do this. Or, well, my friend told me, and I said, is your friend an attorney? No, then I don't want to hear it. So we're trying to manage expectations is the big one, manage expectations. If they're entitled to a free lawyer, get the free lawyer. And we explain that first thing out of your mouth is going to be, I want a free lawyer. And make sure you have your paperwork, and your paperwork is ready. And some of it seems like, your first day of law school, the things that we're telling them. But you're overwhelmed, and English may not be a first language. It may not be a second language. And sometimes it's as simple as, did you ask for an interpreter? And they're arguing with me that, no, they can understand, what's being said. And I'm like, you didn't understand what I just asked, though. Just get the interpreter. So sometimes it's very basic, but sometimes it gets very complicated. So we make sure we prepare them for the next step. And we say, look, going over everything is going to be very overwhelming. Let's focus on what you need to do to be prepared for the next court date. And then come back. Everyone can come back. They are more than welcome. We want them to come back. And some people will come back throughout their whole case, as long as they're not coming back on the same issue and just hoping to get a different answer. But we're more than happy to see people. So we've made a huge difference. And I know because, we're almost like the default button. If the clerks and the officers, and how many times officers have walked people over, if they don't know what to do with somebody, they send them to us. And I say, well, that's what we're there for. We're there to help people. And the attorneys absolutely love it because you're getting your CLEs, and if you're in a firm, you're getting your pro bono hours, which the firms love. And your time commitment is so small. It's usually 1 day a month, but the impact is just incredible. And there is no prep. If you've ever taken on a pro bono client, it's like you're married to them. They just, they never go away, and they constantly call. And since they're not paying you, they know they're not, they know they're not getting the 6-minute bill, so they just keep calling. You come, you volunteer your time, and you leave. So one of my attorneys always said it's the one place he goes without a briefcase. He doesn't need to bring his briefcase. He just comes, and he does it, and he goes. Did I get everything?
Yeah.
Yeah, no, I think that is pretty much. So I'm going to stick at the 15,000 clients and no complaints. We'll end on that.
Definitely. Thank you, Angela. My name is Kwaku Agyeman, as I was earlier introduced. So this is approximately my 6th year doing the Uncontested Divorce program in Brooklyn. I might hurry to say it's probably the flagship program, but I won't be so quick because my judge is here. The numbers in Brooklyn are a lot, and we see a lot of people. How do they find us? These days, people go on the website. My name is there. The Brooklyn program is there, and they're inquiring about uncontested divorce, and so they pick us up. Some of them would phone in, or they would come over to the courthouse. On other occasions, people would just be going directly to the courthouse, Supreme Court, asking about how they can get divorced. So they have no idea what exists. They have no idea what the program does. They probably don't even know about the program. And when they come in there, they're thinking, well, you know how I went to Borough Hall and just got married like one day to the next? That's the kind of divorce I want. That's how they're thinking. I went there, I took a license, next day, so they come in. I'm here to fill my paperwork out. Can I just do it? And so we hand them the booklet. I do work at the health center too. There's a big booklet. Unfortunately, there's nothing we can do about it. It's the law. So we hand it to them, say, this is how you get divorced. And they look at this booklet, and it's absolutely intimidating. If you haven't seen it, you should grab one. But if they put their minds to it, they'll be able to do it. And then there are those clients who will never be able to do it. We're somewhere in between. There's some people who get so intimidated, they say, well, can I get some help? Or we offer it to them just from their reaction. There are those who come in and say, well, I'll get the paperwork. I have an attorney at home who helped me, or I have a friend who did it. It's fine, I don't have time, I got to go. And we say to them, the court also has a volunteer attorney program, and that's cool. And the program is actually great. You get to sit with an attorney, and people just light up the fact that they get to see an attorney, and it's on volunteer basis, and it's free. They love it, and they're going to come in and sit with the attorney. Our program is not, as I inherited it, it's not designed on the basis of income, so everyone is able to take advantage of it. It does have its own parameters. If you have children, we cannot do your paperwork for you unless you went to family court and you already got a family court order, whether it be child support or child custody order. And so you would come in with the order, and then we'll do it. When they come in, generally, and everyone in the courthouse, including the officers at the very door, if they ask, I'm trying to get divorced, they know where to direct them. So they would go to room 122C, which is the General Help Center. There's a pre-qualification process to see if you have your paperwork. and then we set up an appointment. Interestingly, when I realized this program was going to be, I was very comfortable because I've sat in this seat a few times already. Twice a year, I would come here and make a presentation to attorneys who are transitioning from one area of the law to the other, who want to get skills in uncontested divorce. I actually see in the audience a few of the attorneys who have come and worked with me, and they continue to come back. So thank you very much. It's nice of you to volunteer your time as you do. The program is structured such that the attorneys come here for the training. It's a one-day training. We do a presentation using PowerPoint. We go into the program itself and show them how it works. It's a drafting libraries program. Now, in addition, they give us 50 hours and they get a number of CLE credits back. I'm proud to say a lot of people keep coming back because I provide a very healthy, interesting, fun environment. They like the work that we do. I'm a stickler for quality. I try to impart that to them. And many people, by the time they leave, who had no knowledge of uncontested divorce, are very, very proud. I'm currently working with a few students from CUNY who, actually the graduates of CUNY Law, just waiting to be admitted. And in 2 weeks, one of them actually said to me, the one thing I really like is that you look out for all the little mistakes that people just let go. And I say to him, I want you to take something with you. It's a simple uncontested divorce program, but I think it's important that our work product speaks for us. Dora, you did mention something about your little thing that tells the judges that this is coming from you. We also have a little code, we call it HCR, which is Help Center. I'm not sure what the effect of it is, but we want our judges in Brooklyn to know that this came from our office. And so we put HCR Help Center there for them as well. Occasionally things do come back because even though we give the clients the knowledge of how to file, when they arrive, we give them a form. Our intake form does say, it issues the disclaimer, we're not your attorney. You're filing this yourself. We only have a 2 to 3 hour meeting with you, and we do your paperwork for you. So by the time you're leaving, you have a set of papers for your entire divorce case. It turns out that divorce is, in fact, quite difficult. And I put myself in the position of the clients, and I feel that if I were not an attorney, if I didn't do work in this area, would I be able to carry through with this? And I think the answer is no, I wouldn't. And so oftentimes, there are lots of people you give the paperwork to. We give them a one-page instruction. We've tried to condense the court's booklet into one page, which is difficult to do. We have, the numbers of rooms and the desk where you go to get your index number. You go to window 1 for index number, go to window X for notary, which is provided free right there in the court. And yet people do come back and say, which window was it again? And I say, it's written right there. It's window 2 for your notary. So people need attorneys. They need us to walk them through the process. It's very intimidating for them, and I think the help that we give them is very deeply appreciated. There are also those who cannot afford to pay for the court fees. While the program is free, the court fees are not free. And so if you need a poor person's order, which is a waiver, there's a separate application for it. When I inherited the program, it was done together. We increased the times that we do the program by 1 day. So now it's 3 days a week. And then I thought better of it because many people were coming back after the poor person's order. We generally in Brooklyn could take about 2 weeks. They would come back and everything you told them, they've forgotten. So what we do now is we break it into 2. We hand you your papers. We say, look, don't touch these papers. Just, go file the first part. When you're done, come back after the poor person's order. When the judge has decided what they want to do, whether they're granting it or declining it, or they're denying you the opportunity, and you have to come up with the money because they're not satisfied that you're truly a poor person, we will follow through and show you what to do next. And even that sometimes does not help. People would come back with their papers. Oh, I didn't realize there was free notary. I signed everything. No, you're not supposed to do it. There's a rhythm to this. You start, your spouse speaks through an affidavit of service or an affidavit of defendant, and then you continue from there. But increasingly, we're very successful in what we do. I would say that approximately 700 to 800 clients per year will come through our program. If I have a minute, I'll speak for a second about the attorneys that also come to work with us. Is the clock ticking already? Almost, okay. Well, they're here. I think most of you know what we do and like it. Many of them have already gotten the CLE credits, but they never stop coming back. And I will be reaching out to some of you and saying, would you like to come back? So If you know any attorneys that are looking to learn this area of the law, please recommend us to them, and we'll be happy to work with them. Also, a quick plug, in 2 weeks, October 28th, we'll have another program here where we teach the attorneys. So if you know anyone that would like to come and help us, let them know they can go to the court's website and join us. Thank you.
Kwaku,
Yeah.
thank you. Before I go on, since Kwaku's program is an uncontested divorce program, and those of you who are here this morning heard the ethics attorney speak about that horrible uncontested divorce case where the unbundled attorney took the case and basically the litigant thought it had no prior experience, hadn't been trained in uncontested divorce law or divorce law, and believed that the litigant wanted an uncontested divorce, and didn't really explain to the litigant when the litigant told her that she wanted possibly to relocate, or she might have had some equitable distribution issues, the lawyer basically said, "I'm just a limited scope attorney." Kwaku, I just want you to just speak to that for a second to explain, could something like that ever happen in your program?
I don't see it happening. What could happen, though, is things fall through the crack. And so you might have a litigant come in and is still thinking, you know what, I want spousal support, I want maintenance, I want equitable distribution between my spouse and I. And so that's what they're looking for. The pre-qualification process, which gives you the appointment, gives you a lead time of about 2 weeks to prepare yourself for all the documentation that you need for your divorce. And it's made clear that, equitable distribution, there are no issues. As I mentioned, where there are children, you also have to bring a child support order or a child custody order if that's applicable. And so these issues are hashed out. But sometimes clients say one thing, in one area, and then when they come back, they say something else. I tell all the attorneys who work with me, if there's anything that comes to mind, and that's said even here in training, but when they come to me, I work with them sort of one-on-one, and so they on-the-job coaching through that process, I let them know if anything comes up and a person wants equitable distribution or they want spousal support or maintenance, we're very quick to let them know that, this may not be for you because we're not equipped to hold your hand and carry through because that requires ongoing representation. We indicate on the back of our intake sheet that we're not your lawyers. We're here to help you only today, and all we're going to do is sort of draft your papers for you. And I think a lot of people understand that. Those who have these issues, I keep a stash of cards from the Brooklyn Bar Association, and then the Help Center also has long lists of legal services that they can explore. So then we refer them to those services and say, you may want to try these. But increasingly, there's just not enough programs out there, especially for matrimonial. And to piggyback on what the judge was talking about, I work at the Help Center, so I see people one-on-one also. And I think it's the area that the court and generally all legal services really need to look at. There's so many people. A defendant comes in, and here I am, a divorce has been filed against me. There are children, there's property, and they're getting none of it. And they don't have representation. And plaintiff does have representation. So that really increasingly is becoming rampant. We need to look at that. Thank you.
How much time do you want me to go, Ro? Okay. So, hi, my name is Tracy McNeil. I'm special counsel to the DCAJ for Renee Fisher, who's also the director of the New York State Court's Access to Justice program. Since I'm batting cleanup, I'm going to see if I can bring it all back together before we hit our question segment today. So we know that all these volunteer attorney programs do recruitment, they train, and they supervise. But the most amazing part of the programs is that they provide free, buzzword, free, court-based legal information and advice, right, to unrepresented litigants, in addition to doing document prep. Why is this so important? Because these are the people who don't qualify for legal aid or legal services, right? They might not have the money to devote to this, right? And this is the only place that they can go. So we heard about CLARO already. We also heard about the volunteer attorney program in family court, as well as the Uncontested Divorce Clinic and King's Supreme Court. There's also one in Queens Supreme Court as well. In lower civil, there's also the volunteer attorneys program for civil court. So lots of times CLARO's in the evening, and this is when someone can talk to a volunteer to get advice during the day in the help center. There's also volunteer lawyer program for housing, right? As we heard His Honor in the last panel mention that it's not just straightforward contracts, right? It's a bit more nuanced when it comes to housing court. And there, the volunteer attorneys can not only just look at existing court papers, right? But they can look at the predicate notices, leases, right? Maybe Section 8 papers, rent records, or any sort of general housing court documents. We also have created a brand new program in King's Supreme Court. We're trying to meet the needs of the court, and what we were hearing out of King's Supreme Court is that there are days that the help center is not open, and the law library was getting a lot of flow in from unrepresented litigants, and there the law librarian said, you know, we can't answer all their questions, we can't take the flow. And what ended up happening is that in King's Supreme Court, what they did is they formed a committee and they said, what sort of program would be most helpful to our court? And what we began to do is we began to look at what are the most common questions that unrepresented litigants were coming in to the courthouse with. And what we found is that they were, unsurprisingly, matrimonial questions. There were also questions on Article 78, shocking. So we decided to develop a volunteer program around that. And we trained volunteer attorneys mainly on matrimonial, as well as generally Article 78. How do you do all the Article 78? Well, generally. And what we were able to do is to create a volunteer attorney program on the days that the help center wasn't open to alleviate some of the stress out of the law library. But where do all of these volunteer programs exist? Well, many of them exist out of court help centers, right? Last year in 2014, court help centers saw over 55,000 people. Court help centers are staffed by court staff like us. And unfortunately, that's a lot of people coming in. So this is where the volunteer programs are really, really most helpful. There are help centers that attorneys can volunteer in Supreme Civil, as you heard, in family court, but they're under the supervision of court staff. And the main thing that they do, other than to try not to send people back to your courtrooms acting crazy, which is a bit of what they do, is beyond answering general questions and inquiries, but helping them to complete answers, petitions, directing them to the correct DIY, do-it-yourself form programs. And this is another way that we're able to do document prep with people without doing actual ghostwriting. But another huge part is also interpreting orders. The huge distinction that we try to impart for unrepresented litigants that are coming into the help centers is what is the distinction between volunteer attorneys that are going to be coming in and court staff. Is the gift of the volunteer programs is that the volunteers can give advice. Court staff can only give legal information. And what volunteer attorneys can also do is that if they elect to, sometimes they can put pen to paper, as they do with CLARO's program. And as you could hear from the panel before, sometimes just speaking to attorneys and just knowing what all your options are, but having someone say, you know, your choices are A, B, and C, but right now B looks best for you, it makes it a little bit easier to walk into the courtroom and sort of fight for B a little bit harder. This is in addition to arguing, helping them to determine what not only their strengths and weaknesses of the case, but there was a bit of discussion beforehand about lots of times that occasionally people choose to go to trial. And, I think it was mentioned before that, they might not be prepared, but the gift of the volunteer attorneys programs is they at least spoke to someone beforehand, before they made that decision. They at least got to have their paperwork reviewed. And hopefully are making these decisions based upon what's best for them rather than out of anger. But then again, we can only do so much. I know the next panel is going to be talking a lot more about education and training and recruitment. So we'll let them talk about that. And I think I hit right on time.
You did.
Thank you, Tracy.
Good job, Tracy.
We actually have 10 more minutes left because we started 10 minutes late, which doesn't give us a lot of time for questions, considering that we also had a lot of further things to discuss. So let's just try to ask a few questions here. Mark, I believe that you talked about, when you brought up the consumer debt, the origins, the beginning of it, you expressed how it was, and I think Judge Moulton expressed this earlier, about why this particular area of the law was well suited for unbundled legal services. Just want to ask you, and we've had all these areas are areas that we've discussed on this panel that are areas where we see the most unrepresented litigants in the court, where they're, it's really the bread and butter of the court. We've said all along today that not every case is right for unbundled legal services. Would you feel the same way about unbundling if you were running a program? Do you think it's right for like a lawyer for the day in a criminal case or a tax case or maybe even a child custody case? What is it the difference? What is it about those types of cases or the type of case that you do that makes it so much better suited?
That's a good question, but I mean, basically, there are areas of law that have, and I mean, consumer debt is what I'll talk about, is just because of the volume of the cases filed and the kinds of issues that arise in that potential litigation, that area of law is very open to, with a limited scope type of assistance, that defendant is going to have a very, very good chance of a favorable outcome. The issues are simpler, quite frankly, because plaintiffs' papers often are not complete to prove their case, because that's not the business model in the consumer debt industry. The consumer debt industry, we didn't use the term yet, has been very famous for sewer service. We have process servers who have gone to prison. The Attorney Generals in the last years have been very active in prosecuting them. So there are areas that just have very finite sort of factors involved. Obviously, clearly, there are many areas of law that are just not going to work for limited scope assistance.
Right, and Angela also mentioned that you mentioned the areas of the law that you provide assistance within family law, but are there areas that you don't provide assistance? Your attorneys will not give assistance in?
Correct. If it's an abuse or neglect case, juvenile delinquency cases, we do not offer advice in those cases. The majority if you have an abuse or neglect case, you are eligible for a free attorney if you fall within the guidelines amount.
Is that the only reason you exclude those areas is because they get an attorney, or
it's also it opens up a whole new bundle of problems. I mean, it's a lot to get to train attorneys to take on an abuse and neglect case, and it's overwhelming. And if you have an abuse and neglect, that is not something I would ever say is something that can be unbundled. I mean, you need an attorney. If you're facing a neglect case, you need an attorney in the courtroom. It's not something where you can get a 30-minute consultation and feel like, okay, that'll take you through the next court date. You need an attorney in the courtroom.
I think that's really what we're trying to get at is that there are cases that require continuous legal services. When I was saying like a custody case, it's going to be ongoing. You can't give somebody a short period of time on that. The reason that Mark was saying that the consumer debt was so well suited for it was because he can get an outcome right then and there on the day that they see them. The same thing with you, Quick. You're shaking your head, yes. Yeah. So, and I think, Dora's raising her hand. I think Dora has something to say, but I think that we're saying that continuous legal representation, cases that really require continuous legal representation might not be ripe for unbundled legal services, but the types of cases that our panel runs programs in are very well suited to unbundling. And I believe, do you people refer, I think Kwaku, you said you do refer people when you feel they need full service representation, you do refer them to full service programs.
Right. The Help Center has list of legal aid and many other agencies, so we would give our clients a sheet of paper, telling them where to go. We also keep stashes of the Brooklyn Bar Association's cards, and so we say try to, and I see Sydney over there, he's going to come and talk about it. We send a ton of people to him as well. But I also want to add that even as our programs appear to be a one-shot deal, you come in, we do what we can, and you go home, we see people coming back in a way that I don't think the program envisaged from the beginning. So even though this would otherwise be an hour or 2 hours where we're done with you, it's a little bit of a revolving door. And I'm just speaking to the point you're making that there are indeed so many other areas of law that you cannot just unbundle. Even what we think we've unbundled, it doesn't work. It works well, but people do need to come back because it's difficult for them anyway. Yeah.
And Dora, you talked a lot about the retainer agreement, the informed consent, the way your attorneys are trained to explain the scope of the service to the litigant. I'm wondering, have any litigants been confused about the scope of the services? Have you had any issues or problems where they didn't understand that the representation wouldn't continue?
Very rarely we might see someone who has a capacity issue, in which case we usually consult with a consumer law expert and try to see if we can refer it out. Those are very, very, very challenging cases. I just want to say that, in addition to informed consent, which is a ethical obligation that's part of the limited scope assistance, there's also an ethical obligation to inform the litigant if the scope of the case is not suitable for limited scope representation. And it might be because it's very fact specific. It might be because there are affirmative claims. It might be because the legal defenses are complicated. And so, the credit card cases that we see, which are, the bulk of the CLARO cases, are absolutely suitable for limited scope assistance in most cases for all the reasons that Mark described. But there are other types of debt collection cases that are much closer calls and where sometimes we just will refer out for a variety of reasons. So right. Even at CLARO, we have to make certain determinations.
Right. But the kinds of legal services that you do provide, do you see any reason why the private bar and or legal services organizations could not provide similar unbundled legal services?
Well, I think legal services offices historically have provided limited scope assistance. And as long as there is informed consent and all the other ethical obligations are met, I don't see why a private attorney wouldn't be able to enter into a similar limited scope retainer agreement with a client.
Thank you. And I just want to, because we're very time pressed, I just want to go back to the ghostwriting issue that we had before. Our panel they do disclose that the papers were made with the assistance and the preparation of counsel. I'm just wondering, have there been issues in these cases where judges have come back, where they've called up the program or expected an attorney to appear or tried to, have you come back into the case, or has it happened with adversaries? Any of you?
Well, with our program, we help them with their with paperwork, and in family court, most of the paperwork is it's fill in the blank. It really is. You're filling in. It says I am the blank, the respondent, and I object to the order dated on blank, and you fill it in. And the attorneys will talk them through about what needs to go in there, but they will not write it out for them. We make sure we're not going beyond the scope of the representation, and we don't want the appearance of this attorney-client, that they're representing them beyond this limited scope. So they don't fill it out for them, but they do talk them through what needs to go in there, and if they're filing an objection, what needs to go in the objection, if it's a motion to vacate. But
Your program is primarily an advice program.
Yes.
But the CLARO program does a lot of document preparation, and so does the Uncontested Divorce. I'm just wondering, have any of the judges called you in CLARO, or the adversaries wondered why aren't you on the case?
I would say it's the opposite. I think the judges appreciate having opposition papers or a reply paper in a case when one of our visitors is trying to vacate a default judgment. They appreciate that there are some legible documents that make sense and have proper legal citations in them. As was mentioned, it's all documented on each paper that it was prepared with the assistance of a lawyer from the CLARO Clinic. And quite frankly, I think all the judges in Queens have expressed to me that they appreciate getting those papers. And we try to do our best to meet our ethical obligation by explaining in detail what we're putting in those papers. And I would say almost unanimously, I think the judges have felt that we're helping the situation for them.
I just want to say for myself, I've been involved with the CLARO program since 2008. Our programs provided consultations, 18,000 different consultations. There have been 2 cases that came back to me. One's directly from a judge, and another time through volunteer lawyer for the day. We investigated, and in one case we felt there need not be any corrective action. In the second case, we agreed with the judge, and we took corrective action. So that's
Thank you.
our numbers.
I've been told that we can have 5 more minutes. So any questions from the audience for our panel? Otherwise, I will ask them another question. See how good you were? They have no questions. All right. The ideal limited scope attorney, from what we heard from Laura earlier this morning and what we would all picture, is somebody who's more of a savvier litigant who can do, go to you for some tasks and then do the remaining tasks on their own. That's not necessarily the case that we find in these programs. However, we do know there is a large spectrum. We discussed this earlier. There's a spectrum. I think Judge Fine was talking about the continuum of services, that there are people that fall in different places on the spectrum of what they can handle and what they can do themselves. Obviously, you people, you run these programs, you believe that you're giving the people that come to you enough to continue the cases on their own. What I really want to know is, do you think, your personal opinion, Civil Gideon, do you think it's necessary in all cases? Whoever.
I'll go. I'll field it.
It's actually for all of you.
Yeah, I'll start. Is it necessary in all cases? No. Would it be helpful in all cases? You betcha, no question. If there's a straightforward, for lack of a better example, non-pay, is there any non-pay that's straightforward? Where, a tenant has the money and there are repairs and everyone feels as though that justice is served. Was an attorney really necessary there? I'm not sure. A small landlord who feels that she can fill out and file her no-fault holdover paperwork herself, I don't know if it's necessary. However, is she 90 and her children live in South Carolina and she has to come backwards and forwards to the court by herself? Maybe then it becomes necessary. So in true lawyer fashion, I'm going to say depends. But it would certainly maybe make the courts a bit more efficient and maybe get us to justice with a capital J a little bit more.
But I think you answered the question about civil Gideon. Is it necessary in all cases? It depends. That answers the question alone. I mean, we all want civil Gideon. We all want to have a true equal playing field. Although then you'll get into the discussion of who's got the better lawyer. But the question really is, what you've seen in your programs, do you feel that there are people that can benefit tremendously from the services you provide and continue the cases on their own? Dora, I see you.
I want to answer this.
Yes.
I thought a lot about the question because Rochelle asked us to think about it before today's program.
I did.
And I think it's a two-part answer. I think yes. I think it would most certainly help in individual cases, but I think it would change the practice. It's very different when you have a critical mass of defense counsel in a courtroom. It would change, I think, how, in the consumer credit area, it would change debt collection practices. It would provide opportunities for case precedent development. I think it would alter the very industry. And so not only because it would help individual people, but because of the impact that it would have in the court and in the broader industry, I think it would be a very positive development.
Right, which I think Angela talked about how just the presence of the volunteer attorney program in the Bronx Family Court, and Mike Williams spoke about this also, has changed the culture of the court. So we know that's very powerful for both the litigant and the attorney. I believe that we need to wrap up. So I want to thank my panel, Judge Fisher. We're going to go.